last week, Thursday, we heard that the High Court had made a determination. The rules under the OSP's Act are that he is able to seize property and sort of freeze accounts. When he does that, he has to go to court to seek an order of the court to continue the seizure so he can seize it for a short time. He purportedly did that in the Cecilia Dapaah case, and then he filed an application in the High Court according to the way the law works. Cecilia Dapaah's lawyers filed an affidavit in opposition to the application he had filed to the High Court. Therefore, the court had two competing matters to deal with: the affidavit in opposition and the application. The court considered both and came to the firm conclusion that Kissi Agyabeng was wrong, that he couldn't have seized Cecilia Dapaah's property because he didn't demonstrate reasonable grounds, because he didn't show that he's investigating her for any particular offense. But then here's a drama, completely dramatic, very, very dramatic. So Kissi Agyabeng then speaks to Cecilia Dapaah, the Office of Special Prosecutor. I don't know whether it's he himself. Speaks to Cecilia Dapaah and says that here's your money. According to the story that has been told to us, within 5 minutes, they come around her, the little woman sitting in the office, they come around her and say, "We have taken it back." And she's shocked. Because when she was going to the Office of the Special Prosecutor, she called her lawyers and says, "Special Prosecutor has called me. Do you want to come with me?" They said, "Oh, no, it's okay. He's just going to comply with the High Court ruling. So there's no point. You can go." The lawyers didn't suspect that this bizarre, dramatic matter was going to happen. So she shows up there. She says, "Okay, the court says we are unfrozen. Then they grab the thing and they grab her again and say that we have taken it. Okay. Where is the abuse of office? Where is the abuse of power? Where is the wanton abuse of power? A high court says that you can seize the assets when you have achieved A, B, C, D. Reasonable grounds, you've come in good time, you have investigated, you can do that. You agree with that, you release the assets. You have not done 1% of what the court said your law says you should do before you seize the property. Then you seize it again. That is arbitrary, completely arbitrary. And it's a mockery of the justice system. You wouldn't have thought that a criminal law expert would be the one to conduct himself during the 8th Parliament of the 4th Republic, that this is the time that we want to mock the judicial system. Kissi Agyabeng wants to demonstrate that he has enough power to mock the judiciary. He has enough power to bring down the Superior Court of Judicature to their knees. He has enough power to wantonly violate court decisions, and it doesn't matter because he is called Office of the Special Prosecutor by an act of Parliament, an act created by Parliament. For that reason, he believes that he can conduct affairs to mock the judiciary. That's what he's done. That's what Kissi Agyabeng has done. He says, "Oh, you can't seize the money." Okay, people are writing on Facebook and say, "Oh, but Kissi, why did you prepare well? Why did you go to court with that?" Because lawyers are reading the ruling and are agreeing with the judge that, but is that what Kissi did? But is that how you do your work? And then he hears it, and then he's from his faraway location, he orders his people that go talk to her, release the thing, and then grab it again. Let's see what Martin Amidu has to say about it. Let's see what Martin Amidu's theory is broken down into 3. He talks about the exercise of powers beyond the jurisdiction of the special prosecutor. He talks about special prosecutor acting without a reasonableness, and then he also talks about the special prosecutor violating the principles of innocent until proven guilty. It is my pleasure now to send you to the touch screen and let's share what Martin Amidu is saying. He says, 1, the OSP is acting beyond his jurisdiction. It is important for the citizens to understand and appreciate the fact that the OSP has no jurisdiction to deal with any tainted property, quote and unquote, except property which is tainted as a result of being derived, obtained, or realized as a result of the commission of a corruption or corruption-related offense. So that he's saying that the OSP cannot say something is tainted and that's enough to go and seize anything. As stipulated in the 11th offense as defined under the Section 79 of Act 959, there is no tainted property over which the OSP has any power to investigate, which is not interlinked and interwoven with or having been used in the commission of an offense, unquote, which in this case means a corruption offense. There is no independent offense known as tainted property for which the OSP has statutory authority under Section 79 of 959 to go about arresting, searching the premises of citizens without a warrant from a court and freezing them without a prior reasonable ground of suspicion of the commission one of the 11 specified corruption offenses. Okay, I get it. 2. Martin Amidu asserts that the seizure was without reasonable grounds and therefore illegal. Martin Amidu goes on, Mr. Kwesi Agyabeng, without any reasonable grounds to suspect Cecilia Dapaah of having committed or about to commit a corruption or corruption-related offense, such as abuse of public office for profit or other corruption offenses, abused his authority. Kwesi Agyabeng abused his authority by arresting her and searching the premises of her husband and her fishing for evidence of a corruption offense amidst media fanfare and publicity. We have said that already. The High Court on 31st August 2023 refused to permit Kwesi Agyabeng to profit from his unlawful fishing expedition in search of evidence to investigate and prosecute the suspect. The OSP under Kwesi Agyabeng now turns round by his press release dated 5th September 2023 to depend upon the evidence he obtained by unlawful means, for which his application for confirmation was refused by the High Court, to purport to designate the subject matter of his failed application to the court as tainted property, again under Section 32(1)(a) of Act 591, without stating the specific corruption offense he is investigating against the suspect and how the property became tainted property. So that's Martin Amidu's view of the matter.